Okay, picture this. You're a California renter. You think you finally found the right place, gone through all the hassle, the applications, everything, and then bam, you get told, oh, sorry, it's not available anymore.
Right. Or maybe you ask for something simple, like an accommodation for a disability, and suddenly your landlord just seems to be, dragging their feet on fixing that leaky faucet.
Exactly. It just feels off, doesn't it? You start wondering, wait, is this fair? Is something discriminatory actually happening here?
And that feeling, that sense of frustration and unfairness, it's often a sign that your rights might actually be getting violated. It's way more common than a lot of renters think.
Mm-hmm.
And many people in California face these situations, but they just don't know where to turn or, frankly, what protections they even have.
That is exactly why we're doing this deep dive today. We're focusing on navigating housing discrimination, specifically as a California renter.
Yeah.
We've pulled together info from some really key places, the California Civil Rights Department, the CRD.
The big one.
In the Federal Department of Housing and Urban Development, HUD. Plus, we're looking at expertise from groups like the Legal Aid Society of San Diego, California Rural Legal Assistance, Workplace Rights Law Group, Mahigan Law, and just various resources that lay out fair housing rights.
And our mission today, it's pretty straightforward, but really vital. We want to equip you, the listener, the California renter, with the essential knowledge about your rights, about the safeguards that exist right here in California against housing discrimination.
We want to give you some practical information, point you towards resources that can actually help if you run into this stuff.
Exactly. Real help for real challenges.
Okay, so let's start at the beginning. When we talk about housing discrimination in California, what does that actually mean? It's more than just a landlord having a bad day. Right?
Oh, absolutely. It's legally defined. In California, housing discrimination means denying housing or offering unequal terms, conditions, maybe privileges related to housing because of specific characteristics, traits that are protected under the law. And what's really key about California is just how, extensive that list of protected characteristics is. It goes way beyond the federal minimums.
It's good to know. So what are we talking about? What characteristics should renters be aware are protected?
Okay, so under California law, it's illegal to discriminate based on race, color, ancestry, national origin, religion, disability, and that covers both mental and physical disabilities.
Right.
Sex, which is broad. It includes sexual orientation, pregnancy, childbirth, gender, even how someone is perceived in terms of gender. Then you've got gender identity, gender expression, genetic information, marital status.
Wow, okay. Keep going.
Familial status, that means if you have kids under 18 or if you're pregnant, your source of income is protected. Military or veteran status, age, citizenship, immigration status, and even your primary language.
That is a really, really comprehensive list, a strong safety net. And you mentioned perception, so it's not just if you actually have one of these traits.
That's a super important point, yes. The law protects you if someone thinks you have one of these characteristics, even if they're totally wrong. Or, say, if you're just associated with someone who has one.
Like what?
Well, for example, a landlord can't discriminate against you just because your spouse or partner is of a certain national origin. Your association is protected too.
Okay, that makes sense. So how does this actually look in the real world? What are some, concrete examples of illegal discrimination that people might run into, according to the sources we looked at?
Well, it shows up in a lot of ways. The most obvious, I suppose, is just flat out refusing to rent or sell property to someone because they're in one of those protected groups.
Straight up denial.
Right. Another one, which is really damaging, is when they lie and say a unit isn't available when it actually is.
Ugh, that's just awful. It stops people before they even get a chance.
Exactly. It gets your hopes up, you start planning, and then nothing. And it goes further, things like offering different or worse terms.
Like charging more.
Yeah, maybe charging a higher security deposit or higher rent just because, say, you have kids compared to someone who doesn't. That's illegal. Harassment is another big one.
We should definitely talk more about harassment later.
Absolutely. And then there's things like canceling an agreement early based on a protected trait, or even providing segregated housing, like steering all the families with kids to one part of an apartment complex, maybe the less desirable part.
Okay. What about advertising? Can landlords get in trouble for how they advertise places?
Oh, definitely. Discriminatory advertising is illegal. This includes using language in ads that, suggest they want to exclude certain people.
Like professionals preferred or something.
Exactly. Or maybe perfect for singles.
Yeah.
That could easily discourage families from applying, and even screening policies that seem neutral on the surface. They can be discriminatory if they have a disproportionate negative impact on a protected group, like a blanket ban on anyone with any criminal history. That can unfairly screen out people from certain racial or ethnic backgrounds, and it might not be legal unless that history is directly related to whether they'd be a good, safe tenant.
Right. Okay. That makes sense. Now, let's shift focus a bit to a really critical area.
Yeah.
The rights of renters with disabilities. I know there are specific strong protections there.
Yes, this is absolutely crucial under fair housing law. Renters with disabilities have a right to what's called reasonable accommodation.
Reasonable accommodations. What does that mean in practice?
It means landlords often have to make exceptions or adjustments to their normal rules, policies, or services. The goal is to make sure a person with a disability has an equal opportunity to actually use and enjoy their housing.
Can you give us some clear examples? What would that look like?
Sure. A really common one is allowing an assistance animal, like a service dog or an emotional support animal, even if the building has a strict no pets policy. And importantly, landlords generally can't charge extra pet fees or pet rent for these necessary animals.
That's a big one. What else?
Maybe providing a reserved parking spot closer to the tenant's unit if they have mobility issues. Or maybe adjusting the rent due date slightly if someone's disability benefits arrive, say, on the 5th instead of the 1st of the month.
Okay. Now, you mentioned service animals and emotional support animals. There's sometimes confusion there, right? How does that fit into accommodations?
Yeah, that distinction is important. So service animals, typically dogs, are specifically trained to perform tasks for someone with a disability, like guiding someone who is blind.
Right.
Emotional support animals, or ESAs, provide comfort and support that helps alleviate symptoms of a disability, but they don't necessarily have task-specific training.
So can both be accommodations?
Yes, both can be considered reasonable accommodations. But the type of documentation a landlord can ask for might differ. For a service animal, usually its function is pretty obvious, but a landlord can ask if the animal is required because of a disability and what task it performs.
Okay.
For an ESA, a landlord can generally ask for reliable documentation, usually from like a doctor, therapist, or other qualified professional, confirming that the person has a disability and that the animal provides necessary support related to that disability. Just getting some online certificate might not be enough on its own.
Good clarification. What if a renter needs, like, physical changes to their apartment? Like grab bars or something?
Okay, that falls under the right to reasonable modifications. These are physical changes to the actual unit or maybe common areas that are needed for someone with a disability to fully use and enjoy their home.
So grab bars in the shower, maybe a ramp to get into the building.
Exactly. Those are common examples. Now, generally, the tenant is responsible for paying for these modifications.
Okay, the tenant pays.
Usually, yes, and the landlord might require the tenant to agree to restore the property to its original condition when they move out, apart from normal wear and tear.
It sounds like there needs to be a conversation when someone asks for an accommodation or a modification.
Absolutely. The law requires landlords to engage in what's called the interactive process.
An interactive process.
Yeah, it just means they have to communicate with the tenant. They need to talk, understand the need, explore potential solutions. They can't just issue a flat no without genuinely considering the request.
Makes sense.
And just to reiterate, the proof needed for a disability-related request doesn't always have to come from a doctor. It could be from another reliable source who knows the person's situation and needs.
Good point. Okay, let's talk about money. Specifically, source of income. How are renters protected from discrimination based on how they pay their rent? This seems really vital for a lot of folks.
Hugely vital. And California has strong protections here. Landlords absolutely cannot discriminate against you just because of how you pay your rent.
So using things like Section 8 vouchers.
Exactly. Section 8, other housing assistance programs, Social Security income, unemployment benefits, disability payments, child support, any lawful, verifiable source of income. They can't refuse to rent to you or, say, demand a bigger deposit just because you use a voucher.
Okay. And what if someone is using a subsidy, like Section 8, and maybe their credit history isn't perfect? Are they just out of luck?
No, and this is another area where California law recently got stronger, actually, starting in January 2024.
Oh, interesting. What changed?
Landlords are now required to consider other evidence of an applicant's ability to pay their share of the rent if they're using a housing subsidy and maybe their credit report raises flags.
Other evidence like what?
Like statements showing they received regular government benefits or bank statements showing a consistent income or savings. The landlord has to give the applicant a reasonable chance to provide this info and must genuinely consider it. They can't just rely solely on the credit score to disqualify someone if a subsidy is covering a chunk of the rent.
So they still check other things.
Oh yeah, they can still verify employment if applicable, check references from past landlords, confirm identity, things like that. But they can't use credit history as an automatic no when a housing voucher is involved for paying the rent.
That feels like a really important update. Okay, let's move on to families with children. What rights do they have when looking for a place to live?
Okay, so the general rule is landlords cannot refuse to rent to families just because they have children under 18. That's called familial status discrimination, and it's illegal.
Right.
They also can't impose special rules that single out children or make it harder for families to live there comfortably. The main exception is for specifically designated and qualified senior housing communities.
Okay, but in regular housing, what kind of rules targeting kids would be illegal?
Well, things like completely banning children from using common areas like a swimming pool or a courtyard when those areas are open to everyone else.
That seems obvious.
You'd think. Or maybe having rules like children must be supervised by an adult at all times in common areas if there's no similar role for adults. You can't hold kids to a stricter standard. Even subtle things like a landlord constantly saying to a family, you know, this is a very quiet building, maybe implying their kids will be too noisy. That could be seen as trying to discourage them, which is discriminatory.
Right, the subtle stuff counts too.
Yeah.
Now, we touched on harassment earlier. Can we define that more clearly in the housing context? What does that look like?
Sure. Housing harassment is basically any unwelcome conduct that's based on one of those protected characteristics we listed earlier: race, religion, disability, sex, familial status, and so on.
Okay.
It's behavior that's severe or pervasive enough to create a hostile living environment, making it difficult or unpleasant for someone to live there peacefully.
What are some examples? What might a renter unfortunately face?
It can be really varied. It could be overt things like using racial slurs, making offensive jokes about someone's national origin or religion. It could be asking really intrusive, inappropriate questions about someone's sexual orientation or gender identity, or maybe consistently treating tenants from one religious group differently, like enforcing rules more strictly against them. Even things that might seem less direct, like maybe a landlord or manager constantly complaining about the smell of cooking from a tenant's apartment. If the complaints are clearly tied to the tenant's ethnicity or national origin, that could be harassment.
Wow. And what if it's not the landlord doing it, but another tenant?
That's a crucial point. Landlords can actually be held legally responsible for harassment committed by other tenants if the landlord knew about it, or reasonably should have known about it, and failed to take reasonable steps to stop it. They have a duty to address known harassment in their properties.
That's really important for people to know. Okay, it's disturbing to think about facing that. Now, let's switch gears slightly to landlord retaliation. What exactly is that, and why is it so critical for renters to understand?
Landlord retaliation is essentially when a landlord takes some kind of negative action against a tenant, tries to punish them, basically because the tenant did something they were legally allowed to do. They exercise their rights.
Okay.
And California law specifically prohibits this. It's meant to protect tenants from being penalized for standing up for themselves.
So what kinds of tenant actions are legally protected? What could trigger a retaliation claim if the landlord reacts badly?
There's a number of them. Things like formally requesting necessary repairs to make the unit safe and livable, fixing serious problems.
Right, like mold or no heat?
Exactly. Or reporting health and safety code violations to a government agency like the health department. Joining or organizing a tenant union to collectively bargain or advocate for rights that's protected. And also legally challenging an eviction notice that the tenant believes is unfair or wasn't done properly. These are all protected activities.
Okay. So if a tenant does one of those things, what kind of actions from the landlord might be seen as illegal retaliation?
Several things. A really common one is a significant rent increase soon after the tenant acts. Especially under California law, if the increase is more than 10% and it happens within 180 days, that's about 6 months of the tenant's protected action.
A 180-day window.
Yes. And that specific time frame is important because a rent hike like that within 180 days creates something called a presumption of retaliation.
Okay, we need to unpack that presumption.
Sure.
What else counts as retaliation?
Suddenly decreasing services that were normally provided, maybe stopping landscaping or closing access to a common facility without good reason. Engaging in harassment specifically intended to make the tenant uncomfortable enough to move out.
Right.
Serving an eviction notice that doesn't have a valid legal basis, or even making false accusations against the tenant, say to management or in court filings.
Okay, back to that presumption of retaliation you mentioned for rent hikes over 10% within 180 days. Why is that presumption such a big deal for renters?
It's a really powerful legal protection. What it means is if the landlord takes that kind of adverse action within that 180-day window after the tenant did something protected, the law assumes the landlord's motive was retaliatory.
The law assumes it.
Yes, and that shifts the burden of proof. Normally, the tenant would have to prove the landlord's bad motive. But with the presumption, the landlord now has the burden to prove that they had a legitimate, non-retaliatory reason for their action.
So the landlord has to justify it.
Exactly. They need to provide a convincing, lawful reason for the rent hike or the eviction notice or whatever action they took. If they can't provide a good, believable, non-retaliatory reason, their action will likely be found illegal. It's a huge help for tenants facing potential retaliation.
That's a really significant protection. Okay, so let's say a renter in California feels pretty strongly that they've faced discrimination, or maybe this kind of retaliation we're talking about. What should they do? What are the first steps?
The absolute first, most critical step is document everything meticulously.
Document.
Yes. Keep copies of all communications with the landlord, emails, texts, letters, everything. Write down details of any incidents, dates, times, exactly what was said or done, who was there, any witnesses. Keep notes.
Okay, so they've got their notes, their emails, their timeline. What's the next move? Where do they take this information?
One main path is to file a formal complaint with the California Civil Rights Department, the CRD.
The CRD.
You can usually do this online through their website, calcivilrights.ca.gov, or you can mail in a form or even call them to start the process. They have an intake process where they'll review your situation to see if it's something they handle and if they can investigate.
Is there a time limit?
Yes, absolutely. Deadlines are crucial.
Yeah.
Generally, for housing discrimination cases in California, you have 1 year from the date the last discriminatory act occurred to file your complaint with the CRD. Don't wait.
1 year from the last act. Got it. So what happens after you file with the CRD?
If the CRD accepts your case for investigation, they'll conduct their own impartial inquiry. They'll gather info from both you and the landlord, review evidence, maybe interview people.
Do they try to settle it?
Often, yes. They might offer mediation or conciliation services, trying to help you and the landlord reach an agreement voluntarily. But if that doesn't work, they'll complete their investigation and make a finding.
What kind of finding?
They'll determine if there's reasonable cause to believe that a fair housing law was violated. If they find cause, they'll notify both sides. They might then try to formally conciliate again, or they could decide to file a lawsuit on behalf of the state or you. If they don't find reasonable cause, they'll close the case, but that doesn't necessarily mean you have no options.
Right. Are there other routes besides the CRD investigation?
Yes. In California, you also have the option to request something called a right to sue letter from the CRD.
Right to sue letter.
If you get this letter, it essentially allows you to bypass the rest of the CRD's investigation process and file your own private lawsuit directly in civil court.
So you can sue the landlord yourself.
Correct. This is often the path people take if they've already hired a private attorney who wants to pursue the case in court directly. It's an option available in housing cases.
Okay. And if someone wants to explore that legal route or maybe just needs advice on their specific situation, where can they turn for help or more information?
Well, definitely the CRD website, calcivilrights.ca.gov, and the federal HUD website, hud.gov, are packed with information. Great starting points.
Okay.
Also, nonprofit organizations are crucial. Groups like the Legal Aid Society of San Diego or California Rural Legal Assistance, they often provide free or low-cost legal help to tenants facing discrimination or other housing issues. Look for legal aid in your county.
Good advice.
And, for listeners, particularly in Southern California, Orange County, Riverside, San Diego, LA, who might be dealing with specific issues like fighting an eviction, what's called an unlawful detainer, or maybe real estate disputes, or even premises liability, like accidents in apartment buildings. A resource like MartinezLawCenter.com focuses specifically on representing tenants in those areas. That could be a valuable contact.
MartinezLawCenter.com. Okay. Good to have specific resources. And when thinking about legal action, that documentation we talked about is key.
Right. Absolutely essential. Your lease, Copies of discriminatory emails or texts, notes about denied accommodation requests, witness contact info if you have it, all of that is potential evidence. And remember, especially in those retaliation cases, that burden of proof can sometimes shift to the landlord, which is a real advantage.
This has been incredibly helpful, really breaking down a complex but vital topic. So to wrap things up, what are the absolute key takeaways you want every California renter listening right now to remember?
Okay, first, know that you have extensive protections against housing discrimination in California. The list of protected characteristics is broad: race, disability, source of income, family status, gender identity, and many more. Understand those protections.
Right. Number one, know your rights.
Number two, landlords have clear legal duties. Especially regarding reasonable accommodations and modifications for disabilities, they must engage in that interactive process. And they cannot discriminate based on how you legally pay rent or because you have kids outside of senior housing.
Okay. Landlord duties, what's third?
Third, harassment and retaliation are illegal, full stop. Landlords can't create a hostile environment based on protected traits, and they can't punish you for asserting your legal rights. And remember that 180-day retaliation presumption, it's powerful.
Know your rights, know landlord duties, and know that harassment and retaliation are illegal. That's a strong foundation.
It really is.
So the bottom line here seems to be informed about your rights as a renter in California, and crucially, don't be afraid to take action if you think those rights have been stepped on.
Exactly. We really hope this information empowers you. If you feel something is wrong, that you've been discriminated against, start documenting immediately and carefully. And then please reach out to the resources we've discussed, the CRD, HUD, your local legal aid society, or specialized tenant rights firms like MartinezLawCenter.com if you're in Southern California dealing with eviction or related issues. They exist to help you figure out your options and seek justice.
That is excellent advice. It's just so important for everyone to remember that fair housing isn't just a nice idea, it's a fundamental right. It's absolutely key to building a fair and equitable society here in California. Thank you so much for sharing all this expertise today. This was incredibly informative.
It was my pleasure. And, for everyone listening, maybe just one final thought to leave you with. Your home, it's so much more than just four walls and a roof, right? It's your base.
Yeah.
It's where you build your life, access opportunities, find your well-being. When housing discrimination happens, it doesn't just affect one person's housing. It chips away at that foundation. It undermines fairness and equality for everyone.
Call now 714-442-9741. Thank you.